Non-negotiable notice of inquiry. I have tried to look this up on Google, the exact quote there, to find out what that's supposed to be, and it came up with people referencing this and referencing another J6er, so maybe they're using a specific wording that isn't, common, or maybe they made it up. I don't know. I actually can't find out what this means, so if you know what it's supposed to be, let me know in the comments. But let's get into it. Date December 26, 2023, CE. Please take notice 1. I, Frank Giustino, a moral sentient being, inquire into this matter. Please respond within 3 days or dishonor may result. James Emmanuel. And it's basically saying he got incarcerated for a misdemeanor. And I've seen a little bit about this where he claims that he's being treated as a felon even though he doesn't have a felony. And it's asking for information. Also, it goes on for something else here. Will you provide a copy of the bench warrant that has a signature and date of signature of the arresting officer that you said you would provide to me? 11/21/2023 sentencing hearing. See the transcript, which we're going to look at the transcript because it's a fun one. Can this be mailed certified to my Florida address on file? Are you even aware that your documented judicial oath of office from the Department of Justice that you signed under Title 28 U.S.C. Section 453 has the final line, so help me God, changed and capitalized to so help me God? He's still doing the oath nonsense. Whew. Okay. Oh, geez, I like this here. Frank Rocco, pro se, justice has a name, thank you. I declare under penalty of perjury that no attorney has prepared or assistance in the preparation of this document. I had a feeling there was no attorney involved, but let's look at the transcript here. So here's the transcript of the actual trial, which is really fun. All right, I have a few questions about the docket itself. I have been pro se since documents 46 and 40. I'm sorry, 4659 have been on record and they have not been responded to. Is there any reason for that? Because I've been pro se since at least document 46 and I was expecting an answer from the court since then. The court. Right. No. You can file whatever you want. These aren't motions, and so there's no response required. And then he says, it's my understanding document 59 specifically was supposed to be filed by the clerk of the court as a motion, and it wasn't. Instead, it was granted to file. Again, I have been pro se since document 46, and I've been expecting an answer from the court in some capacity. I've only received silence. Also, can a bench warrant that was issued allegedly recently be a copy given to me that has been signed by the executing officer and dated? Sylvia Irving of the Tampa Bay Court provided me with the recent bench warrant. However, it just had a PACER seal of approval, but it did not have a signature of the executing officer. This also followed a bench warrant affidavit that was misspelled as my name. That was not my name. It's spelled Giustion instead of N-O. And it has since been lost in my property since I have been incarcerated, going from jail to jail, and so I would like to see the executing copy of the bench warrant so I can ensure its legitimacy. The court. I issued a bench warrant because you didn't show up for sentencing. As I warned you, in great detail, at the prior hearing what happened if you didn't show up, so I issued the warrant. Would it be too much of an issue to show me the executing copy, the signed copy? Court, it has no relevance. The defendant. The bench warrant is sealed on record, so I am just curious to why the plea and the bench warrant, I believe it's document 60, now has been sealed from record as judicial filings. To my understanding, Judge Jackson was recently quoted in an article talking about how judicial filings, such as plea bargains, and in this case bench warrant, are typically unsealed by the time of the sentencing. My last view of the docket as of late shows that they're still sealed. Is there any explanation why this? Court, I would be happy to provide you with a copy of the bench warrant. The defendant, okay. Signed and executed by the marshal? The court, I signed it. The defendant, no. Just to clarify, the signature on the bench warrant of yours is there. I'm talking about the copy of the bench warrant that has the signature from the executing officer as well. I have the copy that's only nobody signed it. It's blank. I have it on me right now. The court, it was executed because you were, in fact, arrested. The defendant, no, I understand what is being said, but I mean, I would just like to see the actual copy of the executing, just to have as, you know, court of record. The court, okay, so go ahead. The defendant. Yeah, I want to say that I condemn all violence on the day of January 6, 2021. We may all have our differences, may all have our different backgrounds that come from different places, but all violence, I believe, should be something that we should condemn before we have some sort of civil discourse with one another, regardless of political views. That day, I'm going to read my allocation in more detail, but that day I'm putting this in the forefront because obviously the hot button topic of this, I did not want violence. I did not instigate the police. I, in fact, tried quelling the violence. Yeah, and there's about a discovery clip. Let's just keep going for the... it's more interesting when the court gets to reply. Oh, yeah, let's see here. There's some stuff there about Giustino, but okay, I'm going to stop you right there. I can hear this is not the time for the legal argument about some Federal Reserve Act, which has nothing to do... Ooh, we can't skip that. Oh, here it is, here it is. Comes now Frank Rocco of the Giustino family and redeems Title 12 United States Code Section 411 allows for them. They shall be redeemed to make demand be removed from the National Debt Special Drawing Rights, parentheses SDR, the same sense as the original verbiage of Section 16 of the 1913 Federal Reserve Act. Okay, I'm going to stop you right there. I can hear this is not the time for legal arguments on Federal Reserve Act, which has nothing whatsoever to do with this case. And I'm not going to sit and listen to something that is completely irrelevant. If you want to make an allocation about what you did that day and your position and your remorse you have, your thoughts about it, your thoughts about the sentence, I'm happy to hear you. But not anything about a Federal Reserve Act or redeemed people. Oh, the defendant. Redeemed people. It's redeeming unlawful money. It's not some sovereign citizen garbage. It is redeeming unlawful money on demand pursuant to Title 12 United States Code 411. It's about endorsing Treasury notes over Federal Reserve notes. The court. All right. This case has nothing to do with Federal Reserve notes. The defendant. It has to do with there's been a clear violation of 28 United States Codes 453 judges in case USA versus Sino against Frank Giustino by all names and faculty with discrepancies in the process that are preventing justice for Frank Rocco, rendering the plea bargain vacant and thus making sentencing at trial impossible. The fraudulent notes of... There was an interruption by the court reporter. Court, again! Do you want to speak about what occurred that day? If you want to bring another, you can bring an appeal if you want regarding the defendant. I have the court. This case, hold on. The defendant, sorry, the court. You can if you want to withdraw your plea. I mean, if you want to seek, maybe this is a more fundamental thing. If you don't think your conviction is appropriate or lawful, I don't want to go forward with the sentencing. If you want to withdraw your plea because you think it's an invalid plea or the prosecution is invalid, I'm happy to let you file that motion. We'll just hold off here. It sounds like what you are doing, you are not talking about your sentencing, you are attacking the legitimacy of the proceeding. So it sounds like you don't think it's a valid plea. And if you would like to withdraw that plea, I certainly would not go forward with sentencing until I resolve that question. The defendant. I do not want to withdraw the plea. But what I do want is to go home. I want to take time served. I do not believe I deserve the second sentencing memorandum that the government has brought forth. If you look at document 48, the main argument that the government is making for increasing jail time from 21 days incarcerated to 4 months is simply for questioning authority. I think that if this is the precedent that, court, hold on. One thing the government pointed out was that your conduct in the last hearing was as offensive and inappropriate conduct as I have heard in a January 6 hearing so far in these prosecutions. Your lack of respect for the court, for the government. I mean, the government's quoted things that you said in emails to him. They haven't quoted the cursing and other statements you made during the hearing, which I could have found you in contempt of court for. They were so inappropriate. And so it seems to me, based on what the government is saying in that memorandum, is that you have no remorse whatsoever for what you did or any respect for what's happening here. And that seems to me perfectly valid for them to make. And we keep gets good. So I've read ahead to this part. So the moment that the government mentioned remorse, which was halfway through that 6/23/23 status conference hearing, the only thing that I have done from the beginning of that conference to the point that apparently I had no remorse, which makes no sense to me, because if we were to read back in that transcript, it shows that I was simply questioning the jurisdiction and authority of the court. I was looking for answers and said I did not receive any answers. I asked you, Mr. Boasberg, why your oath of office, I believe, had an issue and why that was the case, why it was on Title 18, United States Code, Section 453, and I received silence. And it wasn't to create disharmony between us as people or our positions in this court. It was you want to say a plea or a cry, even to get some sort of answers after having a prosecution that involved a court-appointed attorney who did not do his job on my behalf. The plea bargain has typos with the dates. He ignored me. This is Evan Sugar. He ignored me for 5 weeks. The court. Hold on. So either, as I said, I just want to make sure, do you wish to withdraw your plea? Because you didn't receive you didn't receive effective assistance of counsel or correct advice, or the prosecution was somehow flawed. I want to make sure here before we go forward that the defendant, the only reason I would want to withdraw the plea is if the entire case was dismissed. If the case is not being dismissed, then I do not want to withdraw the plea. Lovely. The court. All right. So you don't want to withdraw the plea. Let's talk about anything else you want to talk about regarding sentencing. I'm happy to hear. Not legal argument regarding the case, but sentencing. Tell me what else you'd like to say about sentencing. I would like to say that I believe I should be released on time served based on the original memorandum over the fact that my own attorney was not doing his job, or the fact that I'm having no remorse, which, if untrue, has nothing to do with the asking authority of a court. Again, going back to the transcript, there was nothing up until the comment made that I have no remorse, that I weren't me having no remorse or being seen as having no remorse, simply because I believe there was a jurisdictional issue that was not being answered to. So my partaking on January 6th, which I have made clear in the beginning of my speaking today, is being misconstrued, and I am very much empathetic towards the people of DC. I've been here for a little bit of time now, and they are very nice, to be quite honest. It's just more of that here. Constitutional rights. There's a 20-page letter that is filing that was not filed because there was sanctions if he filed it. So he's still complaining about his lawyer, but he doesn't want to remove his plea. And the court eventually just says, okay, thank you very much. You may have a seat. And he got his sentence. I forget exactly what it was at the end of this. It's probably here, but it's not super relevant. The defendant here, can I ask one thing? Sure. Something I failed to mention is that I've been dealing with some health issues for some time. So basically, they're talking about health here and stuff like that. But, oh, here's a good one. The defendant, can I enter as no contendo? The court, I am not sure what that means in this circumstance, but if you wish to say that, that's fine. The defendant, yes, no contendo. The court, all right, thank you. Mr. Giustino, when you get out, good luck to you. I'm hoping that you're going to return to your law-abiding path prior to January 6th. Thank you. So yeah, we have this one here, and still going on about oaths. So absolutely nothing appears to have been learned. Nothing.